A very warm good afternoon to one and all who joined virtually through Zoom and Facebook platform for the day 4 of National Webinar Series on Consumer Protection Act 2019 Rules and Regulations. It gives me immense pleasure to welcome you all on behalf of Chair on Consumer Law and Practice, National Law School of India, University, Bangalore. Today's sessions will mainly focus on mediation as an effective tool to redress consumer grievance. So today we have an eminent guest speaker with us, Mr. Shiv Kumar, Advocate, Senior Mediator, Master Trainer, Bangalore Mediation Center, Bangalore. Sir has completed his BA from St. Joseph College, Bangalore, and has completed his LLB from University Law College, Bangalore. He has commenced his career with Ms. King and Partridge Advocates at Bangalore and has established a full service law firm of MS Murthy and Kumar Advocates in 1976 and continues to be in active practice at High Court of Karnataka. Sir was also serving as a faculty of BMS Law College and Bharatiya Vidya Bhavan teaching constitutional law, business law and press law. Sir was been also a member of a consultative group on the Right to Information Act in Karnataka and was also the part of National Consultative Group on Mental Health Act. Sir has drafted the Elders Protection of Rights and Redressal Grievance Bill, an exclusive legislation for senior citizen based on which the current Maintenance Act has been enacted. Currently, Sir is promoting and practicing pre-litigation conflicts management in specific areas of civil law, commercial law, family law, and training counselors, advocates, judges, and members of NGO in conflict management and in alternative dispute resolution methods. Sir is also a certified mediator of High Court of Karnataka since 2007 and has vast and varied experience in court-annexed mediation at Bangalore Mediation Center, which is an initiative of the High Court of Karnataka. Sir has completed the Advanced Mediation Training Program conducted by US Department of Commerce and CLDP and has also completed Commercial Mediation Training Program conducted by JAMS and the Foundation for Sustainable Rules of Laws Initiative, USA. Sir is also a master trainer at Bangalore Mediation Center since 2010 and has trained advocates, judges in mediation and conflict management. With this brief introduction, I welcome you, sir. Now, I request Mr. Shiv Kumar sir to address on the today's topic, that is mediation as an effective tool to resolve consumer dispute. Over to you, sir.
Good afternoon, viewers. It's a great pleasure being here. And what we will do today is to look at mediation, its dimensions, what it actually means, and why it is so applicable, so effective in the resolution of consumer disputes. The way the subject is worded, it says mediation as an effective tool to resolve consumer disputes. I would look at a different dimension of it. I would probably reword it to say, is mediation the most effective method of resolving consumer disputes? That would be the fundamental basis or the paradigm on which I would be making this small presentation to you. Needless to say, what I say to you or what much the thoughts that I share with you need not necessarily be the correct ones. What I say may be open to several interpretations, several questions, several opinions, which is the way it ought to be, because there are no empirical rights and wrongs in the resolution of disputes, be it any form of disputes, including mediation. With this background, let us try and move forward. Now, when we look at the Consumer Protection Act, you will find that a consumer dispute can be resolved in one of three ways. The first one is a civil suit under the Code of Civil Procedure. The second is by the process of compounding, which is also found in the Consumer Disputes Act. And the third one is under the Consumer Courts Act. Under Section 9 of the CPC, a civil suit to enforce a consumer right or a dispute is not barred. Please remember that under Section 9, the CPC says that the courts shall have jurisdiction to try all suits of a civil nature, excepting suits which their cognizance is either expressly or impliedly barred, which therefore means that a consumer dispute also can be agitated, can be prosecuted by filing a civil suit under the provisions of the CPC. It can also have its redressal in the provisions relating to compounding of offenses under the Consumer Disputes Act, which you will see a little later. And of course, the Consumer Courts Act, which is governed by the Consumer Protection Act. Let's take a very quick look at the provisions relating to a civil suit and a comparative table in respect of what happens under the Consumer Protection Act. A civil suit is covered by Section 9. And as I told you earlier, all suits, unless they are specifically barred, are triable and are prosecutable under the Code of Civil Procedure. Section 100 of the Consumer Protection Act says that the Consumer Protection Act and the remedies provided are not in derogation of any law, but is in addition to or supplemental to the provisions of the Consumer Protection Act. Therefore, the Act itself recognizes a dual prosecution method, namely a civil suit under Section 9 or the prosecution or a complaint under the Consumer Protection Act. Now, in a civil suit, generally what happens is that it is a proceeding to enforce legal and statutory rights. It may be contractual rights, it may be property rights, it may be under the Transfer of Property Act, it may be a probate matter, it may be a succession matter. All the enforcement mechanisms must relate to enforcement of a legal or a statutory right. And under the CPA, under the Civil Procedure Code, when a suit is filed, a defense is permitted, counterclaim is permitted, and it therefore follows a regular process of a trial, arguments, and framing of issues, and thereafter arguments and final judgment. What is the difference, therefore, insofar as the CPA is concerned? Please remember that the CPA, which is the Consumer Protection Act, is fundamentally based on torts, as opposed to a legal or statutory right. And a tort has been defined as being a civil wrong. So the first difference in the process under the CPA would be that it is based on torts. It is restricted only to goods and services, as opposed to the civil suit under Section 9, which will encompass every possible kind of suit that you may think of. It refers to enforcement of consumer rights under Section 2(9). I'm sorry, there is a small typo there. It is not 2(10), it is 2(9). And the process under the Consumer Protection Act is summary in nature. Defenses are very limited. You're not allowed to take the kind of defenses that you would normally take in a civil suit. Counterclaims are not permitted under the CPA. And a consumer dispute has been defined under Section 2(8) of the Act. Now, if you were to go to the definition of consumer disputes, it is the largest and the widest amplitude has been given to it. Section 2(8) defines consumer dispute simply as means a dispute where the person against whom a complaint has been made denies or disputes the allegations contained in the complaint. The definition of a consumer dispute does not restrict it to either deficiency in services or goods. But considering the totality of the legislation, the intent of the legislature, the explanation that follows the Act, it is clear that it would be limited to deficiency in service or goods. And now, under the amended Act, new concepts like an unfair contract, like product liability, like class actions have been introduced. So these would be the fundamental differences between any proceeding in a civil court and a CPA. I am drawing your attention to this because under the CPC, you can still file a case enforcing a consumer right. But since the CPA is a special legislation, the first argument would be that because it's a special legislation containing exclusive provisions only related to consumer disputes, it would obviously be a more effective method of dispute resolution rather than a civil suit. That is the reason why I drew your attention to this. Now, what is this criminal action under the CPA? If you were to look at Section 88 of the Consumer Protection Act, there are penalties that are prescribed. It's a penalty for non-compliance with directions of the central authority. There is imprisonment for 6 months and fine up to 20 lakhs or both. This is also a provision for enforcement that is provided under the Consumer Protection Act, also relatable to and relating to a consumer dispute. Then you have Section 89. It relates to false and misleading advertisements, which is followed by imprisonment for 2 years and fine up to 10 lakhs or both. Now, these two offenses are compoundable under Section 96 with the permission of the court where the prosecution is pending. Why I am drawing your attention to this is that on the one hand, you have a civil suit under Section 9 of the CPC, which is a long drawn process where any suit can be filed. On the other hand, you also have CPA, which allows you to go through a faster remedy of a consumer court, plus a compounding provision in respect of Section 88 and 89. So what is the platform? What is the basis on which this has arisen? My submission or my argument would be that Section 96 has inbuilt into it. It's based on essentially on the platform of a negotiated settlement, which means mediation. What is compoundable? The meaning of compoundable is that I discuss with the person against whom the complaint has been filed and see whether we can resolve that issue and go back to the court and say, we have resolved this issue and therefore please do not prosecute me any further. We will close the issue. What is the basis of this? The basis of this obviously would be mediation or an intervention which results in a settlement of the dispute. Now let's look at some of the commonalities of a suit and the CPA complaint under the CPA. Please remember that any proceeding under the CPA in pursuance of a complaint and the suit are both judicial proceedings. In other words, there is a judge or a third person who sits in judgment over your complaint versus the other person who is responding to your complaint. Both these are adversarial and adjudicator in nature. Adversarial meaning I take a stand which is adverse to that of the supplier or the service provider. He takes a stand which is adverse to me, and either the civil suit or the commission, the district or the state commission, adjudicates on that dispute. And finally, what does it do? Both the court and the commissions determine who is right and who is wrong. The focus is constantly on who is right and who is wrong. And why is that focus required? That focus is required because once you find somebody right, that person has to be compensated for the wrong done to him by the other person. So in both these proceedings, be it a civil suit or a suit for enforcement of a consumer dispute, you will find that the focus of either the courts or the Consumer Protection Council or Consumer Protection Courts is on right and wrong. Both the CPA proceedings under the CPA and the civil suit under Section 9 are controlled by the Civil Procedure Code and the Consumer Protection Act. And please remember, one of the most important commonalities of both the civil suit and a complaint under the Consumer Protection Act is that the courts cannot traverse beyond the pleadings or the complaint. The court and the commissions under the Consumer Protection Act are bound by what the complainant has said in either the plaint or in the counterclaim or in the complaint that is filed in the CPA. This is what we call a restrictive provision. It cannot traverse beyond what has been placed before the court. And both the court and the commission must confine itself to the material that is placed on record and give its finding on that basis. And finally, one of the commonalities is that both these civil courts under Section 9 and the commissions under the Consumer Protection Act always determine if the relief that has been claimed can be granted or not. This is based on an assessment as to whether the person who has approached the court has established his right or not, or in the case of a consumer complaint, has he established deficiency or not. It has therefore been restricted to examine whether, on the facts that are given to it, can the commission or the court grant the relief that is claimed. Nothing more can be done either by the commissions under the Consumer Protection Act or under a suit under the Civil Procedure Code. Now let's very quickly look at what are the reliefs that can be granted by the court and by the CPA. Remember, in the CPA, in the Code of Civil Procedure, there are no specific provision in the CPC which specify the reliefs that can be granted. Why is it so? It is so because under Section 9, the civil court has the power to try any suit of any nature unless it is specifically barred. So the question that the civil suit will examine is, do you have a right? Have you established that right? Where does that law or that right come from? Which law or which statute does it spring from? And can I grant that relief or not is the sole question that the civil court will examine. As I've already said, it is based upon the legal and statutory rights that are sought to be enforced. The courts will decide if relief claim should or should not be granted. The party's right to frame relief. See, in both the civil suit and in the Consumer Protection Act, the party who goes to these courts has the right to frame a relief in the manner he wants. If you go to a civil court, you can ask for a declaration saying that this practice being followed by this particular supplier amounts to unfair trade practice. It depends on how you frame that relief, how you word that relief. Once that relief is framed by the party approaching the court, it is up to the court to decide whether it can grant that relief or cannot grant that relief. Following from that principle is the very, very universally recognized principle that no court can grant the relief which is not claimed. If I have not claimed a relief, the civil court nor the Consumer Protection Court can go beyond that and say, even though you have not asked for this relief, I will still grant you that relief. Please remember, that power is available only to the high courts under the Article 226 of the Constitution, because the courts have held that under Article 226, when there is a violation of a fundamental right, the relief can be molded, irrespective of the kind of relief that you've asked for. That molding the relief is not available either to a civil court or to a Consumer Protection Court. We will see why that is so in the next slide. As I said, the relief that is claimed by a person who goes to the civil court cannot be expanded because it is not provided in law. No innovative relief can be granted. This relates to the earlier proposition that I made, that if a person asks for a relief, the only determination that the civil court can do is to find out whether it can grant that relief or cannot grant that relief. It cannot get into an innovative mode. It cannot create solutions. It cannot create some innovative relief that can be granted, except under Article 226. So in a civil suit, what is it that happens? Either a suit is decreed or the suit is dismissed. This is what happens in a civil suit, whether or not the suit relates to enforcement of a consumer dispute or it relates to enforcement of any other statutory right under the law. Now let's look at what are the reliefs under the CPA. As I mentioned earlier, the liability under the Consumer Protection Act based upon torts. The only reliefs that the Consumer Protection courts can grant is specifically enumerated in Section 39 of this Act. The courts, the consumer courts, I keep using the word consumer courts. When I use the word consumer court, it means district forums and the state forums and the national forum or national commission also. So the only reliefs that these consumer courts can grant is very clearly specified in Section 39. And what are those? It can direct that the defects pointed out by a laboratory be removed. It can direct that the goods be replaced. It can direct the refund of a price, or it can direct that interest be paid. There can be compensation for loss or injury. There can be compensation for product liability. It can direct that the defects in the goods and services be removed. It can issue a direction that you discontinue the unfair trade practice that you have been indulging in. It can also issue a direction to discontinue the restrictive trade practice. It can issue a direction to discontinue offering hazardous goods for sale, or it can direct that you withdraw the hazardous goods from sale. It can direct that you cease manufacture of hazardous goods, or it can issue an injunction in the order of an injunction desisting from offering hazardous goods, or it can ask that money be paid for loss or injury to a large number of users, which is class action. It can by itself issue corrective advertisements if there are faults in the advertisements issue. And it can issue an order to cease and desist from issuing any misleading advertisements. Now, apart from these reliefs that are enumerated in Section 39 of the Act, none of the consumer courts have any right or authority to grant any other relief. So what is the difference between the civil suit and the consumer protection proceedings under the Consumer Protection Act? Nothing. The civil courts under Section 9 will determine whether the right you have asked for can be granted in the context of a statute or a right that you claim to exist. In the case of a CPA, the relief itself has been enumerated in Section 39. So the Consumer Protection Act also says you cannot go beyond this, and therefore restricts it to these reliefs that are claimed. Now, let us see what is it that a mediation can do. Given the background of what I have told you about a civil suit and a Consumer Protection Act and the reliefs that it can be granted, in this whole confused process, mediation steps in. How does it step in? It steps in because under the Amended Act, Chapter 5 of the Act has been introduced. The concept of mediation has been introduced. And based on the jurisprudence of mediation, together we will today determine whether mediation is the most effective remedy for resolution of consumer disputes. Now, please remember, we have a fairly clear idea of what a suit under Section 9 of the CPC will entail. We also have a reasonably clear idea of what the reliefs that can be granted under the Consumer Protection Act. We have just seen that. Both these cannot grant innovative reliefs. So where is the answer? The answer lies in mediation. Why does it lie in mediation? Because mediation fundamentally is a dispute resolution process founded on perceptions. It's possible that I may see an object in a different manner than the way you see it. There's a remark that I may pass, the service I render to you. I may think I have rendered the best possible service to you, but you may have a different perception of the same service. So the entire process of mediation is founded on differing perceptions of parties. And these perceptions depend upon who you are, where you are, why you are, what's your mood that you're looking at, what were you expecting in this transaction, etc., etc., etc. Perceptions is a product of a combination of several human factors, which include psychology and other attitudes. So mediation looks at this process as being founded on perceptions. Mediation gives importance to perceptions. Now, mediation is based on dialogue and negotiations. As I mentioned to you, both the civil suit and in the Consumer Protection Act, it is based on an expansion of right and wrong. Who's right, who is wrong? Do I have a right, don't I have a right? But in mediation, the process shifts from right and wrong to a dialogue and negotiated settlement. Mediation, therefore, is a non-binding third neutral party intervention to facilitate a mutually beneficial settlement. It moves away completely from the paradigm of right and wrong, of your having violated my right and my having to be compensated for the fact that you have violated my right. It is therefore a non-binding third neutral party intervention. It's an intervention based on dialogue or negotiation to facilitate a mutually beneficial settlement. So who is a mediator? Please remember, a mediator is not a judge. A judge in a civil court is a judge, and a consumer protection courts have judges. A mediator is not a counselor. He doesn't tell you what to do or what not to do. He doesn't advise you. He's not an advisor. He doesn't determine moral right and moral wrong. He doesn't say that you have done right or you should have done this or you should not have done this. A mediator is not an instrument of social change. A mediator does not sit there to see whether society can be changed by a change in attitudes. The role of a mediator is that of a facilitator. All that a mediator does is to facilitate a negotiated settlement between two warring parties, be it in a civil court or in the Consumer Protection Act. Please remember that. So what are the principles of mediation? The principles of mediation are very, very easy to understand, actually. One of the fundamental principles is that it is not based on authority or power. Contrast this with a court, where a judge sits, he has authority, he has power, he can make you do things that you don't want to do, he can prevent you from doing things that you actually want to do. And that authority springs from statute, which is conferred upon the judge. Similarly, in the case of a Consumer Protection Act, a court, a commission, or a forum, or the national or the state commission, the authority is vested in them. And by virtue of that authority that is vested in them, they exercise power, which means power has shifted to them to determine who's right and wrong. Mediation does not recognize this power. Mediation believes fundamentally the principle that a mediator does not have power or authority at all because he's a facilitator. He does not look at right and wrong. Mediation is not adversarial. It's based on dialogue. It's based on conversation. Therefore, there is no focus on right and wrong. Mediation does not believe who is right or wrong. We don't even care who is right or wrong. The focus is on seeing whether we can resolve the dispute that is before you. Mediation is party-centric. In the case of a court, the litigant who goes to either the civil court or the Consumer Protection Court is not the primary stakeholder. Mediation recognizes that it's a party-driven, party-centric process, and therefore prime importance is given to the parties. We give importance in mediation to the concept of self-determination. What does this mean? It simply means that I, as a disputant, I, as a person who is a consumer who has a complaint against the supplier, have the right to determine whether I should file a case, whether I should settle the case, whether I should enter upon mediation, whether I should settle it, if so, on what terms should I settle it. All this power shifts from the judge to yourself. Imagine the seat of power in the case of a civil court or in the case of a Consumer Protection Act lies with that person who has been appointed as a judge. He determines what's good for you and what's right, not good for you. But in mediation, the fundamental jurisprudence principle is that the boss here who determines what can be done and what cannot be done is the party who approaches or who has a dispute or a complaint against the supplier or any other person. Therefore, parties retain absolute control over the decision to settle and the terms of control. Now comes the most interesting principle of mediation. It's a voluntary process. Now, what does it mean? It simply means that nobody can compel you to enter into mediation. No court can compel you to say you shall participate in mediation. I, as a party who has filed a case in the Consumer Protection Court for redressal of a grievance, have the authority to decide whether I will participate in mediation and participate for some time, and then suddenly decide and say, I don't want to participate. Once I decide that I do not want to participate, there is nobody on this earth who can compel you to participate in the mediation process. Look at the beauty of it. I can withdraw from that mediation. Suppose you have filed a case in a court of law against a supplier or against any other person. Can you withdraw? If you withdraw, there is a certain consequence that flows from it. But in the case of mediation, I withdraw from mediation without prejudice to any of my rights, either under the law, nor are there any penal consequences that flow from my withdrawal. That is the beauty of the mediation process. Now, in this context, there is section 37 of the Act. If you look at section 37(1), you will find that section 37 actually refers to the process for mediation. It reads like this. Section 37 is reference to mediation. At the first hearing of the complaint after its admission or at any later stage, if it appears to the District Commission that there exist elements of settlement which may be acceptable to the parties, except in such cases as may be prescribed, it may direct the parties to give in writing within 5 days consent to have their dispute settled by mediation. Look at the wording of it. On the one hand, mediation says that it is a voluntary process. And yet under section 37 of the Act, what it says is, where it appears to the District Commission that there exist elements of a settlement which may be acceptable to the parties, it may direct the parties to give in writing within 5 days consent to have their dispute settled. So there is an inherent contradiction here. And I think it would be useful for members of the commission, if they are, I'm sure they are, I don't know whether they are part of this webinar. This section 37 is a contradiction in terms, because the principles of mediation say it is voluntary. You can't compel me to participate in mediation. But section 37 says, if the commission feels that there is an element of settlement, it shall direct the parties to give their consent, which in my humble opinion is a complete violation of the jurisprudence principles of mediation. How do we get over it? We get over it by giving it a purposive interpretation and ignoring the direction and persuading the parties to go in for mediation. That is what will make it effective, rather than a direction that you shall go to the mediation process. Now let us look at the subsection 2, where the parties agree for settlement by mediation and give their consent in writing. The District Commission shall, within 5 days of receipt of such consent, refer the matter to mediation, and chapter 5 should apply. So on the one hand, you have voluntariness, on the other hand, you have consent, which according to me is a violation of the principles of mediation. But that does not take away the process or the beauty of the mediation process. It also does not detract from the principle that in a consumer dispute, mediation would obviously be the most effective way of resolving it. Now there is a regulation that has also been passed. The consumer report regulations have been passed, and under regulation 11.5, the regulation 11 talks about the mediation proceedings. And in regulation 5, it says, if a party does not participate in the mediation proceedings, the Consumer Commission may direct such a party to participate in the proceedings. On the one hand, mediation is a voluntary process. The mediation regulations recognize that it's a voluntary process. And yet in regulation 11.5, it says, if a party does not participate in the mediation process, the Consumer Commission may direct such a party to participate in the proceedings. Therefore, the answer to this would lie in saying, let us read down that provision. Let us substitute the word direct, but say, persuade the parties to participate in the mediation process. So that regulation will not become odious. It will not become unconstitutional. It will not violate the principles of mediation. It will be a purposive interpretation of the word direct. And therefore, read that the word direct, read it down to read as follows. If a party does not participate in the mediation proceedings, the Consumer Commission may persuade such a party to participate in mediation. Now, what happens is, if you direct a party to participate in the mediation process, it is possible that the parties will attend the mediation process, but will stall the mediation process and ensure that mediation does not move forward at all. Therefore, my argument to this audience today is that this should be read down. Let us look at we'll come to the other ones later. Therefore, notwithstanding the contradictions in 37.1 and the regulation number 11.5, my submission would be that it does not violate the core principles of mediation, because by simply substituting an interpretation, you can bring it within the principles of mediation. Right. Now, what does mediation do? Mediation has a very, very interesting concept. It identifies conflict and dispute. It postulates the principle that a dispute is simply a manifestation of conflict. Now, in a civil suit, let's say A has filed a suit against B for encroachment, for an injunction, because B has encroached on the property. Now, that is the dispute that we see in a court of law. Now, what mediation actually does is to go behind that dispute and try and understand why you have done what you have done. What is the history behind it? We go back in time to understand the core of this conflict. We understand why and where this conflict has arisen, which has manifested itself in the suit for an injunction. I keep using this. I'm going to use this example again. It's like the difference between a homeopathy treatment and allopathy. Allopathy treats symptomatic. You have a headache, you are given a crocin. But homeopathy says, let me find out why you're getting that headache. There must be something wrong with the system. There is something deeper. There is something at the core. And that is what homeopathy tackles, which is exactly what mediation will do. Now, mediation goes to the root of the matter, tries to understand if I remove that basic defect or the conflict at the root, disputes will automatically resolve itself. You will not find this concept in either a civil court or in the Consumer Protection Act. Now, the next question that arises is, does this distinction actually apply in consumer disputes? It can apply in a civil suit. Why does a grandson file a suit against his grandfather? There may be a deep-rooted conflict. But in the case of a consumer dispute, particularly individual disputes which relates to deficiency of service or defective product, is there any scope for conflict, which means a long-standing conflict? In most cases, it is not. Let's take the case of you go and buy a refrigerator. You have no conflict with that man, with that dealer. You don't even know him before you go there. So the question of saying I'll go back in time to understand where this conflict or this dispute is arising most often does not arise. It's a pure and simple dispute. I have bought something from you. It is not working. Please replace the goods. So this concept and distinction of conflict and dispute most often would not arise in the case of a consumer dispute. Therefore, mediation would be that much easier in a consumer dispute rather than in a civil court, is the submission that I'm making. When you don't worry about why this dispute has arisen, in other words, not worry about going back 50 years in time and finding out what the grandfather had said to the father, which has resulted in filing of the suit, this resolution of a dispute becomes that much easier. We also have a very interesting concept in principles of mediation. It's called interest and position. When I go to a civil court and file a suit against my neighbor, I ask the court, please issue an injunction asking him to demolish the wall that he has constructed on my property. I am taking a position in law. I am saying the law gives me these rights. My neighbor has violated that right. I want that wall demolished. That is the position that I'm taking because it is founded on sound principles of law. Now, what mediation says is, all right, you have taken that position, but what is it that you actually want? Is that what you want? Or is there something else that you're looking for? Are you worried that because of the status of the compound wall, something is happening to your property? Is rubbish being thrown across the wall to your property? Or is there any other interest that is bothering you? Interest and position differ in the sense that a position is what you want. Interest is what you need. What I want, what I need. These two concepts are very, very relevant and very meaningful when you talk about a civil suit or any contractual or statutory rights that you're seeking to enforce in the civil court. Now, again, the next question is, are these that important in a consumer dispute? And I'm talking of an individual consumer dispute. Let us not talk about unfair contracts that have been, that concept of which has been introduced under the Consumer Protection Act. Let us also for a moment not even talk about the class action suits. Let us say I go and buy a mixie from a dealer. Now, the mixie does not work. Is there a possibility that I take a different position from my interest. Again, my argument would be in such a simple case, the answer is simple. I have got a defective mixie, you please replace it with Duxil. The position and the interest therefore merge, and therefore mediation becomes that much easier in a consumer dispute for the simple reason that my interest and position both merge in the case of a consumer dispute. I don't have to worry about the distinction. Now in mediation, there is no apportionment of blame. Remember, in a civil court or in a consumer protection case, which the consumer forum decides, there is always saying X is wrong and Y is right and X is wrong. Mediation does not apportion blame because mediation is not concerned with blame. Mediation is simply concerned with saying, here is an issue, here is a problem, let me see how I can resolve that dispute. Mediation is governed by confidentiality, neutrality, which means that whatever transpires in the mediation proceedings is kept completely secret. Even the court that sends the case for mediation is not entitled to know what happened in the mediation process. Rules have been framed for court annexed mediation now in civil cases. The court cannot even ask a mediator to come and depose or be a witness in a proceeding and testify as to what went on in the mediation process. Look at what happens, therefore, in the mediation. Look at the strength of this clause. Mediation process goes on. Both the parties in a consumer case completely talk about each other's needs, each other's wants, secure in the knowledge that nothing of what is said here will reach either the court or will reach outside. That is the level of confidentiality and neutrality we presume. Now, in this context, there is one regulation that has been framed. It is 11.7. It reads as follows. Says the record of proceedings shall be prepared by the mediator on every date and shall be signed by the parties or their counsel, authorized representatives or attorneys. So what this regulation requires is maintenance of records. Now again, we need to read down this provision. What it refers to is record of the proceedings, which means so-and-so came, so-and-so did not come, the complainant came, the respondent came, they wanted time or some discussions took place and it is adjourned to another date. In other words, we need to understand regulation 11.7 to mean that there will be no record of what the parties actually said in the proceedings, but the procedural aspect of it, namely who attended and who did not attend, can be recorded. So the submission again would be that regulation 11.7 would not violate the principle of confidentiality and neutrality insofar as the mediation is concerned. Let us move on to the next principle. Please remember that mediation shifts focus from settlement or compromise to resolution. You may accuse me of saying that this is only a play on words. Believe me, it's not. When we tell somebody, I say, why don't you go and settle this matter? Why don't you go and compromise this matter? There is always an element of giving up something. You are saying, give up something and forget about all this litigation. Why don't you go and settle it? Whereas mediation refuses to use the word settlement or compromise. It simply says, let us resolve the dispute. Now, how can this happen? We will see a little later. Now, in the case of a court or in the case of a Consumer Protection Act, there is always a winner and a loser. If the consumer succeeds in a consumer court, he is the winner. The person against whom an order is passed is the loser. So there is a constant happy party and unhappy party. Well, in the mediation process, there is no loser, no winner, because it's a win-win situation for both. And why is it a win-win situation? Because the mediator simply acts as a facilitator, understands the needs of both the parties, understands what they are happy with, and will promote a settlement by a process of dialogue and discussion. Now let's quickly get to what Chapter 5 of the Act says. Now, Chapter 5 actually introduces mediation for the first time in the Consumer Protection Act. Section 74 requires every consumer cell or district commissions and the state commissions to establish a mediation cell. So it is now statutory for every mediation cell, or every consumer forum or a district forum or the state forum to ensure that a mediation cell is established. Now, section 75 also prescribes empanelment of mediators. It says, for the purposes of mediation, the National Commission or the State Commission or the shall prepare a panel of mediators to be maintained by the consumer mediation cell attached to it. So far, it is very good. We have no problem with it. But the next part of the section makes it a little difficult to take in. It says, to be maintained by the consumer mediation cell attached to it on the recommendation of a selection committee consisting of the president and a member of that commission. Having been a practicing lawyer for 49 years of my life, I find this completely arbitrary. Why is it arbitrary? Usually a consumer forum has 3 members. Now, out of those 3 members, the president and 1 member are entitled to select mediators who are recommended, or a panel is created by a selection committee on the recommendation of selection committee consisting of the president and a member. The selection committee is also the president and the member, and the same persons choose who are going to be the mediators. Therefore, my opinion on section 75 would be that it needs to be re-looked at, and this arbitrary power that is vested in the president and the selection committee has to be diluted to make it a more transparent provision. Then look at section 76. The district commission or the state commission shall, while nominating a person from the panel of mediators referred to in section 75, consider his suitability for resolving the consumer dispute. See, in the case of a civil suit, which is referred to mediation, it could be subject special mediators may be required. Domain expertise may be required. Maybe an IPR, maybe a patent matter, maybe a copyright matter, maybe a venture capitalist, maybe finance, maybe builders. These are specialized laws. These are specialized branches of the law. And therefore, it may make sense to say that I need somebody who is well versed in that law. I want somebody who is able to understand what a letter of credit is. I want somebody who can understand the financial aspect of the matter. So it makes sense in the case of a civil case, which goes to mediation, to say that we shall have specialized subject specialist mediators. But when we introduce the provision in section 76, please remember the typical characteristic feature of a consumer dispute is what we read out to you in section 39. You give me faulty goods, replace. Give me back my money. Therefore, section 76, which says that I can choose a mediator depending upon the nature of the dispute, is otiose. It's redundant, because practically every dispute before a consumer forum can be mediated and intervened by anybody who is a trained mediator, because no subject specialization is needed, no domain expert is needed. Now, section 78 goes further, and it says that if there is a complaint against the mediator, the commission has the power to replace that mediator after giving an opportunity to the mediator who sought to be replaced. All right, now they go through the mediation process. What happens thereafter? Section 80 prescribes that a written agreement has to be signed by all the parties and their representatives. The question that arises is, suppose there are 10 issues to be resolved, or suppose there are 3 issues to be resolved. I claim in my consumer dispute complaint that I need replacement of the goods. I need compensation to be paid. I need interest to be paid. I need reimbursement of my auto rickshaw fare from my house to the consumer forum since I've traveled 40 times. And in mediation, through the efforts of the facilitative process of a mediator, the parties agree that only a replacement of goods will take place without reference to the other 3. It is possible in mediation to resolve some of the issues that are sent to mediation and leave the other issues that are not resolved to be discussed and to be decided by the consumer court. So a partial settlement is possible. Now, if no settlement is reached, then the mediators will report to the commission that the case has not been mediated upon, and therefore that the case should go on before the court. Now, let us look at section 80 and section 78 and 80. I mentioned to you a little while ago that the civil courts and the consumer courts can either grant the relief that is asked for or refuse the relief that is asked for. There can be no innovative resolutions. Let me take the same example that I took. If I buy a refrigerator from a well-known manufacturer or a dealer, and I find that the refrigerator has not worked, I go to the Consumer Protection Act, file a complaint, and what can the consumer court do? It can decide, examine whether there was a defect. If there is a defect, it can give one of the reliefs that have been specified under section 39. It can't do anything more. But in mediation, what the mediator can do and the parties can do is to say, all right, you have given me a defective defective refrigerator. Please take back the refrigerator and give me some other product of equal value. I may say, I don't want your refrigerator at all, but I like the brand, so I'll buy a radio, I'll buy a microwave. Alternate reliefs are possible in the mediation process, which is not possible either in the civil court or under the Consumer Protection Act. Because in the civil suit and the Consumer Protection Court, the only thing that they can decide is, are you entitled to one of the reliefs that is specified in section 39. Please understand the vastness, the sheer innovativeness of the mediation process. I may tell this guy, I don't want your refrigerator, I don't want your money back, doesn't matter, but I'll buy something else. Neither the courts under the CP Act can do it, nor can a civil court do it. And that is one of the fundamental beauties of the mediation process. We also have mediation rules that have been framed. Rule 4 of the mediation rules clearly specify what are the matters that cannot be referred to the mediation process. For example, it says that matters that relate to proceedings in respect of medical negligence resulting in grievous injury or death cannot be referred to mediation. They say that matters which relate to defaults or offenses for which applications for compounding of offenses have been made by one or more parties, fair enough, because there is a special provision for compounding. Cases involving serious and specific allegations of fraud, fabrication of documents, forgery, impersonation, coercion. These are all very grave offenses under the Indian Penal Code. Now, the mediator cannot determine whether there is a fraudulent check that has been given or the signature has been forged. And therefore, it is for that reason that under Rule 4, it is barred from being sent to mediation. Cases relating to criminal and non-compoundable offenses, cases which involve public interest or the interest of numerous persons who are not parties before the commission. Now, I have my own arguments against this Rule 4, but I don't think we have the time to get into that argument. But at some later point of time, I would request you to give your thought to this Rule 4 and examine why is it that these cases should be barred at all. Mediation is a negotiation process. It's a process by which parties determine what they need and what they don't need, including medical negligence cases. I have, in my personal capacity as a lawyer, appeared for both institutions and patients in consumer cases. And my own individual opinion is that it is entirely possible to resolve even a medical negligence case, because in most cases, these disputes arise from lack of communication. Imagine a court, imagine a Consumer Protection Commission. The parties, namely the institution that has rendered the service and the person who has suffered the damage, cannot even get into a dialogue, and that is why there is a conflict. But in mediation, they sit at the same table. The mediator acts as a facilitator, makes the parties understand the case of each other, understand the needs of each other, understand the perspectives of each other, and therefore there's no reason why all these cases should be barred. However, that is what the law is, and we will follow it. Now, the more offensive part of it comes next. It says, provided that in any case, other than those mentioned in this rule, namely the ones that I've read out now under Rule 4, the commission before which the case is pending may choose not to refer it to mediation if it appears to the commission that no elements of a settlement exist, which may be accepted to the parties, or that mediation is otherwise not appropriate having regard to the circumstances of the case. Now, why I object to this is a judge sitting in the Consumer Commission may not be a trained mediator. He may not have been trained for 40 hours or 45 hours as a mediator. Therefore, what is the context? What is the mental makeup of that person who looks at a case and decides whether it has an element of settlement or not? Mediation looks at perspectives. The question is, can a presiding officer of a state commission or a national commission or a district commission understand in its entire perspective the concept of position, of interest, of needs? And therefore, if he or she cannot understand that, the proposition I'm making is that this proviso actually curtails the mediation process. Therefore, there's something that needs to be done about this proviso to regulation 4. Then Rule 3 requires the commission to set up a panel of mediators on the recommendation of a selection committee comprising the president and other members. We have looked at this already. Rule 6 also prohibits initiation of arbitral or judicial proceedings while in mediation. So there's a blanket bar, namely, if you are in mediation, you will not exercise your legal rights of going into arbitration or a judicial proceeding. But that does not mean that if the mediation fails, you cannot go to court. You can. It's simply suspended during the period the case is in the mediation process. That is to ensure that the parties are in a better frame of mind to negotiate rather than constantly be thinking about my court and my right of law. Therefore, a judicial proceedings is barred only during the period the mediation is pending. Now look at Regulation 3. Regulation 3 prescribes the eligibility of mediators. Now, who are these mediators? Very quickly, I will read out to you. I won't say anything more after that. Retired judges of the Supreme Court of India, retired judges of the high courts, retired members of a consumer commission, retired districts and session judges, retired additional and districts and session judges, or other retired members of the higher judicial services of a state, retired judicial officers having experience of not less than 10 years, an advocate with a minimum experience of 10 years at the bar, the mediators empaneled with the mediation cell of the Supreme Court of India, High Court, or a district court, that is the existing mediators who have already been trained by the MCPC, that's the mediation committee and mediator of the Supreme Court, a person having experience of at least 5 years in the mediation or conciliation, experts or other professional with at least 15 years experience or retired senior bureaucrats or retired executives. These are the people who are considered to be eligible to be appointed or for empanelment under the mediators. I am basically a great cynic. And therefore, my objection to this is, we have in India today over 10,000 trained eligible mediators. These 10,000 mediators have been trained by the Supreme Court, the Mediation Conciliation Project Committee of the Supreme Court, have been trained by high courts. There are a large number of mediators who have been trained in the United Kingdom, in Europe, in US, and so on and so forth. Therefore, the question I raise for your consideration and your comments today is, why are we creating a body of retired judges and retired judicial officers to get into mediation after they have finished their judicial tenure? I know there will be a lot of people here who will disagree with me and are probably cursing me for having said this, but when we look at mediation, we do not want the judicial approach. Mediation does not look at law. Mediation does not look at right and wrong. We need people with people skills. Mediation requires communication skills. It needs a huge levels of understanding of human nature. Not that other people cannot acquire it, but why do we reinvent the wheel when there is already a huge manpower resource which is available? Now, the code of conduct is prescribed in Regulation 10, which talks about you being neutral, you not having any connection with the parties to the dispute during the dispute or afterwards, a person who is not accused of any offense involving moral turpitude, and so on and so forth, which is pretty normal, and there are no complaints against that. Now, the process of mediation that is prescribed is exactly similar to what I have already mentioned to you. That is the mediation process that is to be followed. Now, having said this, we will take questions from you, but before I conclude, I would like to summarize by saying that this whole presentation has been geared to impress upon the participants that you do have a right in a civil court to go to a civil court and file a consumer complaint, no problem. You also have a right to go to the the courts that are created under the Consumer Protection Act and file your complaints, no issues. But that right to fructify into something fruitful takes so much time, and it is constricted by the provisions of the law, that mediation offers you an open house resolution possibility. In any consumer dispute, as I pointed out to you, the issues are very, very simple. Defective goods, deficiency in service, or in class action, where there are goods that are spurious or that are injurious to public health or misleading advertisements, whatever. All these are independent disputes that exist without reference to a deep-rooted conflict. And therefore, mediation is able to sit down and say, is this what you would be happy with? Mediation gives you the platform to tell the mediator that this is what I am actually looking for. Let's forget the law. Let's forget long-minded arguments. Let's forget what my statutory rights. This is where I am. A tort has been committed. I need to be compensated for my wrong. And therefore, I would conclude with the very basic affirmation that it is not a question of is mediation more effective for consumer disputes. I would convert that into a positive assertion that mediation is the only effective method for resolution of consumer disputes. Thank you for listening. I hope you've got something from me in this in this presentation.
Thank you so much for such an excellent and informative session, sir. Thank you. Now I request Professor Ashokar Patil to take over the question and answer session. Over to you, sir.
Thank you, Akshay. It's excellent presentation from Shiv Kumar sir on mediation, covering all the provisions of CPA Act 2019, Rules 2020, and Regulations 2020. Sir, there are questions. I will take one by one, and I will also, along with you, wherever needed, involve myself. So first question is, sir, as you said, why only mediation is incorporated in CPA 2019? Why not other ADR such as arbitration and conciliation?
Right, that's pretty simple to answer. Why? Because arbitration is also an adjudicatory process. In the case of a court, there is a judge. In the case of an arbitration, there's an arbitrator. There is essentially no difference between an arbitration process and a judicial process. Both determine right and wrong. Both apportion blame that he's right and he's wrong. Both determine the question of right and wrong. Whereas mediation says, I don't care who's right, who's wrong. We focus on resolution of the issue that is on hand rather than trying to focus on what is right and what is wrong. Please remember, arbitration is a form of privatization of justice. The forum is shifted from a court hall to an arbitration hall. The judge is called a judge there, he's called an arbitrator here. And mediation has nothing to do with the adjudicatory process. It's a dialogue-based participatory process. And therefore, we prefer mediation.
Yes, sir. Sir, next question is, what are the qualifications of a mediation required to be empaneled mediator at the mediation cell attached to Consumer Commission?
As I mentioned to you, the regulation makes a distinction between eligibility and appointment. The eligible people are retired judges, as I mentioned to you, a long list of 9 people. Namely, retired judges of the Supreme Court, retired judges of the High Courts, retired members of the Consumer Commission, retired district and sessions judges, retired judicial officers having experience of not less than 10 years, an advocate with a minimum of 10 years experience, mediators empaneled with the mediation cell of the Supreme Court or the High Court or the District Court, person having experience of at least 5 years in mediation, and experts or other professional with at least 15 years experience, or senior bureaucrats or retired executives. These are the eligible people. Now, the qualifications have not been prescribed anywhere. This is what I mentioned. Under Regulation 5, which I did not read, but I will read to you now. Regulation 5.3 says, the selection committee shall determine its procedure for marking its recommendation, and after taking into account the suitability, integrity, as well as relevant experience of the candidates, recommend a panel to be maintained. So what are the 3 qualifications that the selection committee looks at? It looks at suitability. We have no clue. It is not defined as to what is suitable and what is not. Then it says integrity and relevant experience. These are the only 3 qualifications that are required. But I can tell you what you need to be an effective mediator. You need to have extraordinary communication skills. You need to understand human psychology. You need to understand human beings. You need to stop being judgmental. You need the capacity to understand a position which says this also is, rather than this ought to be. Most of us have this habit of saying this is not right, this is not right, this is not the way it should be. Now, these are the qualifications of a personality of a mediator. None of that is found in the regulation. So if you satisfy the conditions of suitability, integrity, and relevant experience, you're entitled to be impaneled. I hope I have answered the question.
Yeah. Sir, in continuation with your clear answer to this, as you said, just anybody cannot become a mediator. It's a skill one must acquire through. That's why the Supreme Court manual says 40 hours rigorous training. So that's why we should look into once again this part, who's maybe retired judge, but if he has already undergone that mediation training, then it's good. If it is not, then they should undergo this 40 hours training. Then they can deliver effectively this mediation process.
Let me answer that question in 2 forms, 2 dimensions. Regulation 9 actually says the mediator shall be given appropriate training in conducting mediation by such experts as may be nominated by the mediation cell, and it shall be obligatory for them to attend such training. No doubt it is there. The greater problem with judges becoming mediators we have faced in the last 15 years, my being a mediator, is the judicial approach has to be substituted by a different approach. See, I am not condemning judges. I'm saying a person who has been a judge for 40 years of a life, to change that chip and unlearn that process takes a longer time than for people who have not been judges. That's all. I'm not saying they should not be. They certainly can be. In fact, some of the new thought on this is, when you move into something known as evaluative mediation, what we do today in the world is facilitative mediation. A mediator simply facilitates a settlement. There is a concept known as evaluative mediation, where you evaluate the strength or weakness of the case. If that is what is to be done, then obviously the judges should have a better experience because they have already evaluated and spent their life being judges. But I agree with you entirely with the adequate training and both practical and theory. It is not impossible for judges to become trainers strong. But my point of objection was that we already have a manpower resource of 10,000 people in this country trained. So that should be given top priority is what I was saying. That's what.
Yes. So next question. The new act provides that mediators shall be entitled to get fees, which shall be decided by the president of a district commission or state commission, as the case may be. But whether the parties would be willing
Good question.
settlement, where imposition of this fee is the consumer to move for mediation.
This is one of the most sensitive issues that we have ever faced in mediation. Now, the court annexed mediation that we do in the Bangalore Mediation Center is pro bono. We don't get paid. But under Regulation 8, it talks about fee of mediators. It says a consolidated fee in a successful mediation shall be paid to the mediator who conducts the mediation proceedings from the time of reference till their conclusion. So there is a fixed fee component that is to be paid to the mediator. Now, that is not too bad, but the question is who pays it? The fees of the mediator empaneled with the Consumer Commission, including costs of secretarial assistance and ancillary expenses, shall be fixed by the president of the respective Consumer Commission, case-wise, considering the nature of the dispute. Let's say there is a consumer case where 5,000 rupees is involved. Will a mediator be acceptable and agreeable to take 100 rupees as a fee? Is the question. Then it also says, in an unsuccessful mediation, half the aforesaid fee will be paid. Then it further says, the fee of the mediator shall be shared equally by two sets of parties. See, on the one hand, mediation, we say mediation is a voluntary process. I can't compel you to participate. On the other hand, when I say you go and I will agree to participate, you say you pay a fee. That's what Regulation 8 says. Then it says the mediator who successfully conducts part of the proceedings will be paid such fee as may be fixed by the president of the Consumer Commission. So there is an inherent contradiction between subsection 1 and subsection 5. The fee shall be deposited in advance with the mediation cell. Now look at this whole concept. This is why I say it's a very sensitive subject. First of all, you direct me to go to mediation. I go to mediation. What do you do next? Deposit the money in advance. I deposit the money in advance. Mediation fails. I come back to the consumer court for resolution by a judicial process, but I have also lost that money. But there is also a provision for recovering that money from the party that loses in the consumer court. So let's be clear about one thing. Mediation as of today in India cannot pay your bills as of today. But in the next 10 years, maybe 10 to 15 years, it is possible that it will reach a great level of efficiency, and it could become the most sought after dispute resolution mechanism. But if you're looking today that I will become a mediator and build a house in 1 year, go a little slow on it. It may not be possible, but it may become possible.
Yes, sir. Okay. Next question is there any provision to refer pending cases to mediation?
In fact, it is only pending cases that refer to mediation or the CPA. It is also a form of court annexed mediation. There is private mediation, there is institutional mediation, but that is not court annexed. Under the Consumer Protection Act, only cases that are filed before the consumer court or the state commission or the district commission can be referred to mediation. So the sine qua non for utilizing Chapter 5, which is mediation process, is that there must be a case that is pending. Otherwise, they don't get jurisdiction. You have to go to private mediators who will do either mediation or conciliation and try and resolve the dispute. The principles remains the same. So please remember, it as of today, it is only court annex mediation, be it under the Consumer Protection Act, be it under the Civil Courts Act, be it under the Family Heirs Court Act, be it under the Companies Court Act, be it under the Senior Citizens Act. All these are pending proceedings. Otherwise, they are out of the court annex proceedings.
Sir, another question. If case is related to unfair trade practice, which is affecting the whole class of consumers, if that case is referred to mediation, then is it one person, maybe you're saying it's a confidential, there itself it closed, but other people who are innocent consumer, they are suffering, they continuing that particular sufferance.
That's right. There is a problem in referring class actions and trust actions and product liability cases to mediation, because all the consumers are not represented. It's the order representative capacity, the suit in a representative capacity under Order 8. So technically what would happen is, if there is a settlement that's arrived at, it would necessarily have to be published, given publicity to, and the procedure that's followed under Order 8 would have to be followed, treated as a representative suit. But again, nothing prevents it from being referred, because what is the issue? The issue is your product hazardous? Has it caused damage? If so, how much damage has it caused? How many people have been affected? Is the Bhopal gas leak tragedy? How many consumers are likely to be affected? What is the compensation to be paid? Whom do I direct the compensation to be paid to? How much shall I quantify? It is definitely possible, because it's again a civil liability. It's in terms of compensation and money that can be directed to be paid by the commission in case of class actions. Of course it can. But I don't know whether there are any class actions pending right now before the consumer courts. I'm not aware of it, but it certainly can be done. I would believe that.
Sir, another question, any difference between the old Act 1986 and new Act 2019 on mediation process?
The old Act did not even have mediation.
Yes.
There is a question. Chapter 5 has been introduced only in this Act. And that too after a battle that we fought for God knows how many years with the government. Mediation as a concept came into this country only in the year 2004. It's an American concept. And therefore it filtered down first to the civil courts, civil disputes. And then slowly it moved to the high courts and then to the Supreme Court. And thereafter to these multiple legislations. So chapter 5 is introduced only now. It wasn't even there earlier. Not at all. So that is a fundamental difference. Then you have, as I said, you have only regard to mediation. That's it. That's it. I can't hear you. Your audio?
Yeah. Yes, sir. Sir,
yeah.
Next question is, can complainant have the choice to select his mediator?
These are all very intelligent questions. And theoretically, under the jurisprudence of mediation, a party to a mediation must necessarily have the right to choose the mediator he wants. But under the regulations that have been framed now, the commission is given the right to choose. I just read that out to you. Wait, let me read that out to you again.
Mediation proceedings, sir?
Yes, it's a mediation proceeding.
11,
I think. 11 is the
yeah,
one.
in regulation.
No, it's we have given the choice of empanelment, free of mediators, code of conduct. Yeah, it's under 76, section 76. The district commission, the state commission, or the national commission shall, while nominating person from the panel of mediators referred to in section 75, consider his suitability for resolving the consumer dispute involved. So the right or the entitlement vests with the commission, which again, according to me, I'm a very puritanical mediator. I believe that the right must vest with the party and not with these people. It's like arbitration. When you have a panel of 3 or 4 arbitrators, you can pick and choose your arbitrator. That same right must be given under this act.
Yes, sir. Sir, another question. If commission directs parties to mediation, can either of them still withdraw from the mediation?
See, under the act and regulations as have been framed now, the power to withdraw is not given, because there are costs that will involve. If you withdraw, then there are costs. Costs can be imposed on you. If you look at if a party does not deposit its share of the fee or the cost of mediation, the Consumer Commission may, or on the application of the mediator, direct the party in default to deposit the cents. The opposite party will deposit, and the other part, no other party deposits the share of the party. The Consumer Commission may terminate the mediation proceedings, and if he does not want to participate in the mediation, no such provision has been made in the regulations. So what will happen? It says you shall direct him to go and participate. That is a lacuna that we find here also. But if we on the one hand admit...
Sir,
is there a problem?
Yes.
Here, under regulation 11.5, if a party does not participate in the mediation proceedings, the Consumer Commission may direct such a party to participate in the proceedings. There's a direction. Now, the Consumer Forum is not a court. Therefore, there can be no contempt. It's only a forum. So if I decide not to participate, the case may go back to the, am I audible?
Yes, sir.
Yeah, right.
You're audible.
Let's look at it differently to whichever gentleman or person asked this question. The commission has the power to direct a party to participate. Now, you can direct me to attend the mediation, but you can't direct me to participate. I can keep my mouth shut in the mediation process. I may not even open my mouth. There is no law today that can compel me to open my mouth and participate. I hope I'm right. I think I am right in that. So there is a lot of drafting irregularities in this whole regulation. First of all, when we agree that mediation is a voluntary process, you cannot compel anybody to participate in the mediation process. It's not possible at all. Therefore, the only thing a party who is directed to attend the mediation proceedings can do is to attend the mediation proceedings, but not participate effectively in it, proactively in it, so as to show that the mediation has failed. That's all that can be said.
Yeah, in continuation with your answer, especially the Consumer Commission, before sending a case dispute to the mediation, they ask for written consent from the parties.
Yeah.
So both parties, if they don't want, they may not give the written consent there itself.
Yes. Yes, but there is a provision for directing. That's the point I'm making. There is a provision for under 37.
So when
you are absolutely right. At the first hearing, if you look at section 37(1), at the first hearing of the complaint, after its admission or at any later stage, it appears to the district commission that there exists elements of a settlement which may be acceptable to the parties, except in such cases as may be prescribed. It may direct the parties to give in writing within 5 days consent. So if I don't want to give consent, you can still be directed to appear. There is a flaw here. The flaw because it is in violation of the fundamental principles of mediation itself. Namely, you're encroaching on the voluntariness. Even under section 89, what 89 of the CPC says is where it appears to the court that there is an element of settlement, it shall direct the parties to opt for one of the modes of settlement. But there, in practice, what happens is, unless there is consent of both the parties, nobody, the courts are not directing it. If you look at section 89, and if you look at AFCON, or both put together, where it appears to the court that there exist elements of a settlement which may be acceptable to the parties, the court shall formulate the terms of settlement and give them to the parties for their observations. And after receiving the observations of the parties, the court may reformulate the terms of a possible settlement and refer the same for arbitration. It's not that section 89 is happily worded, but AFCON takes over and says what is to be done. But when you have 37(1), which says you shall direct me to give consent, where is the voluntariness?
Yeah, if that's one point. And anyway, which cases can be referred, that options are there available.
That's
And
right.
if they strongly, I mean, the basic principle of mediation itself is a voluntary process. So nobody can force. Even they force, they may come at any time. I'm not happy with the proceedings. So that comes. And if case is settled, then the court fee, whatever amount is paid, it will be refunded. Otherwise, the court fee may not come back.
No,
But
in the case of a civil suit, it's only 75% that is refunded.
but in a consumer case, full amount is refunded.
Yeah, what is the fee you pay?
Court fee.
I know what is the court fee you pay in a consumer court?
Whatever,
10 rupees,
sir.
20 rupees, 100 rupees, that's about all.
Yeah, whatever. So that's the encouragement for settlement through mediation.
Well, yes.
Sir, sir, another thing now, another 5 minutes will go.
I have no problems.
Okay. So one question, many questions on online mediation is coming up.
That's
so
your area.
Yeah. Just I will take that question about online mediation. Yes, now it is a digital era, and even now all the courts are going online, and even National Commission, some state commissions are hearing the matter online. So now in future, these mediation should also go online. So that should be the better way, because during this COVID situation, everybody is safe if it happens through online mediation than physical mediation. And all the basic principles of physical mediation is applicable to online mediation also. There is no compromise in the ethical rules or principles or code of conduct. All those things are still applicable to online mediation. So now a lot of platforms are there, as we are doing now, Zoom platform. Under this, all the facilities are there. You can do caucus session, you can do joint session, you can upload the documents, you can, if you don't want to show your face audio, you can do, then all the facilities are available. You can make use of these things, these technology, and we can shift to online mediation. But under the Act, it is mentioned that attached to district commission. So that word, so they have to liberal on that. They should allow online mediation. Ultimately, we want settlement, not on technical ground. We should not struck. So my request is, all the state commission, district commissions should liberally interpret that and recognize those mediators who are well equipped in doing online mediation. And there are institutions which are having all the facilities of online mediation. Those mediation centers can be used while doing these types of mediation. So that is my personal opinion on the online mediation. We have done a lot of things like this. Yes, sir. Over to you.
So there's one question that has been asked by Mr. Nishid, which seems interesting. He says, after mediation resolution, can any of the dissatisfied parties file a suit in a civil court? The answer is an emphatic no. Because once you settle and sign on the settlement, two things happen. One, the dispute comes to an end by consent of the parties. And the Supreme Court has clearly laid down the law that once you have signed a settlement in consent, you can't file another proceeding challenging your own settlement. Okay, unless you allege that the mediator compelled me to sign this settlement.
Yes.
Or that the mediator was neutral. He was taking the side of the other party. All the grounds available to you for challenging the validity of a contract under the Contract Act will be available to you with the settlement if you can prove that it was done by coercion or fraud or the other conditions available. Otherwise, it is final. It cannot go beyond. And that's the beauty of mediation, by the way. One word.
Yeah, that is clearly given under section 41.
That's right.
Appeal against the district commission. So if it is settled through mediation, then there is no appeal available to the against the decision of the district commission. Sir, another question, mediation in banking, telecom, insurance sectors, already they are doing, and there is a separate redressal agencies are there, ombudsmans are there. Why CPA is covering that for mediation?
Okay, that's a very difficult question to answer. An ombudsman.
Sir, may I?
No, just one observation. An ombudsman is not a mediator. Please remember. An ombudsman discharges quasi-judicial functions. Please remember that. He's a neutral person who decides something. Mediation does not decide anything. It provides a platform for negotiation. Telecom sector, they have their own people who are doing mediation. Now, suppose you and I and Mr. Professor Patil are in dispute with each other about something, and I make him the arbitrator, or his junior the arbitrator, or my junior the arbitrator. Is there or is there not a conflict of interest? Therefore, the Supreme Court has said, now in case of arbitration, if there are two corporate bodies that are indulging in arbitration, the employee of one of the employers cannot be an arbitrator because there's a conflict of interest. So therefore, just telecom may not be, those guys may not be actual neutral mediators as we understand we ourselves as mediators to be. Sorry, sir, I interrupted your answer.
No. Sir, for this, yes, we know that regulatory authorities are there, sector-wise, ombudsmans are there, but they have their own limitations. And as sir said, they are not act as a mediators. So once you go, you cannot come back. That will be on merits, they will decide, even though if you are not interested. And another thing, it is left to the consumer to select which mode he wants to settle the matter. If he is happy with the mediation under Consumer Protection Act, let him come. Or if he is happy with I want only the amount which they have to pay, I don't want mental agony and other expenditure. So then approach an ombudsman. And there are some regulatory authorities which are providing their own independent redressal system, like in insurance, IGMS, Integrated Grievance Redressal System, but they have their own limitations. So there you cannot argue or bargain anything, whatever they decide, you have to follow. But in mediation, you can discuss openly, voluntarily. So that is the main difference or merits of the mediation.
I would also like to add there. If you take a banking dispute between a banker and a customer, see, the bank has very strict guidelines and parameters within which it has to be resolved. Whereas in mediation, in a consumer protection case where two consumers are a manufacturer or a service provider and an individual is involved, there are no barriers to creating solutions. You think out of the box. But where there are financial institutions and public sector undertakings, the telecom sector, they are bound by certain limitations that are inbuilt into their system. And what happens is, let us suppose the general manager of a telecom company comes to mediation and says that the claim made against the consumer is in arrears of 50 lakhs and he settles for 10 lakhs. His problem is tomorrow he will be in the dock because there's an accountability up the hierarchy. So it's not that mediation does not work. For mediation to work, it must be an open field. You can't restrict the field. You can't say here is a football field which is 20 by 20, you operate only within that. No, mediation cannot work there. Mediation must say, give me a platform where I can think creatively, think out of the box, innovative, creative solutions. That is, as of today, a little difficult in these public sector telecoms and so on and so forth.
Yeah. Sir, last question. Will the report of the mediator, which is submitted to the Consumer Commission, detailed report or only crux of the settlement points?
There are two things. One is a report of the mediator. The other is a settlement itself that is recorded. The settlement itself is a document which is in the nature of an agreement, which records all the terms of the settlement. Who is to do what, how much is to be paid, etc., etc. Complete details. That is signed by the parties and their authorized representative. The mediator sends a report saying this is what has happened, encloses that settlement and sends it back to the court. And in all court annexed mediation, there is one stage which we should have explored earlier. It is this. Once a mediator arrives at a settlement and the parties sign the settlement, the entire set of papers along with the agreement and the mediator's report goes back to the court, namely the Consumer Commission. The Consumer Commission will look at it and see whether it's in accordance with the law, whether it's within the parameters of the law, and will accept those settlements. Once it accepts it, it becomes a decree or an order of the court.
Yeah, correct. Yeah. Sir, last question once again.
No problem.
What is the time for completing the mediation under CPA that is given in regulation 11, regulation 11, 3 months? And if both parties are, if the mediator thinks that it may be settled by extending a little more, then with the approval of commission, he may extend, but the period is given 3 months.
That's right.
And another thing, they should not, the opposite party should not misuse this mediation to drag the case for another 3 months. So what is the solution?
All right, the solution here lies in a competent, sensitive mediator. If you are a person who has understood the human nature, it will take you 10 minutes to understand whether the opposite party is fooling around or whether it is genuine. Believe me, it's a technique. It's a skill that you will learn as you go along, and you will turn around and say, okay, I can see this guy. This guy is pulling a fast one. He's trying to buy time. In fact, it says that one of the regulations says that mediator also must be satisfied that if he's satisfied that there is no possibility of a settlement, he can terminate the proceedings. He can say, no, there is no point. I say, look, all this ultimately, guys, I'm sorry I'm addressing the guys, but all those participants, mediation is a skill. It's an art. It's not a science. There is no law which says if you do this, this will happen. If you do this, this will do this. Every human being is a different bundle of facts, contradictions, and ideologies. If you're able to tap that, in 2 minutes, you'll know whether the guy is bullshitting you, whether he is wanting to settle or not settle. So therefore, in 3 months, if it does not settle and you've had 4 or 5 sessions, you will know whether he wants to settle or not. You tell me, you imagine you buy a refrigerator worth 25,000 rupees. The guy comes and wants to drag it on. Is it that difficult to figure out whether the guy is going to settle or not settle? What is the issue? Either give me back my money, take back the product. That's it. Under 39, that's all that can be done. So it's a skill. You guys we have to learn that skill, and that can come out of a lot of experience dealing with humans, and being sensitive. That's about all. Nothing else.
Right, sir. Thank you very much, sir. I'm concluding question and answer session. I'm now requesting Akshay to take over.
Thank you, sir. Now let us move for the vote of thanks. So it's my honor and privilege to extend vote of thanks for the day 4 of National Webinar Series on Consumer Protection Act 2019 Rules and Regulations. Today I take opportunity to put all my gratitude into words on behalf of Chair on Consumer Law and Practice, National Law School of India University. I would like to thank our today's guest speaker, Mr. Shiv Kumar, Advocate, Senior Mediator, Mediator Trainer, Bangalore Mediation Center, Bangalore, for taking his precious time and consenting to be the guest speaker for technical session 3. Thank you, sir.
Thank you. Thank you for listening.
I also thank to all the participants who have taken out their valuable time and attending the session. I would also like to thank our beloved Professor Dr. Ashokar Patil, who always support us in all the activities with kind heart. Thank you, sir. Lastly, I once again thank you one and all. With this, I conclude technical session 3 of National Webinar Series on Consumer Protection Act 2019 Rules and Regulations. Kindly join us for technical session 4 tomorrow sharply by 3:30 p.m. Thank you one and all.
Thank you.
Thank you, sir.
Thank you very much, sir.
You're welcome, sir. Thank you.
Thank you.
We'll meet up again.
Yes, sir. Thank you.
Thank you, Yadav.
Thank you, sir.